Today we're going to be presenting on Locke versus Davey. I'm Emery Klosterman.
And I'm Evan Long. In this presentation, we'll talk about who was involved in the case. The two parties that were involved in the case were a student named Joshua Davey and a man named Troy Locke, who was a representative for the state of Washington. We'll talk about the facts of the legal case, which regarded Joshua Davey's scholarship that he earned from the state and whether or not he should be able to use that scholarship to pursue a degree in theology. We will discuss the legal issues of the case and whether or not the state of Washington violated his rights of the Free Exercise Clause, the Establishment Clause, or the Free Speech Clause by denying him access to this scholarship because he wanted to pursue a religious degree. We'll also discuss a few similar cases that the court may have used to influence their decision. Lastly, we'll express our opinions and who we think was right and some reasons why we think that.
So now we're going to dive into the parties of the case. On one side, Joshua Davey was a college student enrolled in Northwest College, which is a private Christian college located in Kirkland, Washington. This college is a typical four-year college with an emphasis on liberal arts education and has Christian values. Davey had previously received a Washington State Promise Scholarship, which is a scholarship of a couple grant. However, his application for the scholarship to assist him in his pursuit for a theology degree was denied by the state because of its policy against using public funds to support religious education. And this denial led to the basis of the case, where the Supreme Court addressed the conflict of state funding and religious education. Troy Locke, on the other hand, was the defendant of this case. He was a representative to the state of Washington, and he was the Washington State Commissioner of the Office of Student Financial Assistance at the time of the case. His role was to enforce the state's policy regarding the use of public funds for education, including the constitutional provision prohibiting funding for religious institutions.
Next, I'm going to talk about the basic facts of this case. Joshua Davey earned and qualified for the Promise Scholarship. The state of Washington established the Promise Scholarship Program to assist academically gifted students with post-secondary education expenses. In accordance with the Washington State Constitution, students may not use the scholarship at an institution where they are pursuing a degree in devotional theology. Students may, however, attend private and Christian schools. In order for a student to be eligible for the Promise Scholarship, a student must meet academic, income, and enrollment requirements. For the academic requirements, a student must graduate from a Washington public or private high school and either graduate in the top 15% of their graduating class, attain a cumulative score of 1,200 or better on the SAT on their first try, or get a score of 27 or better on the American College Test. For the income requirements, the student's family's income must be less than 135% of the state's median income. Finally, the student must enroll at least half-time in an eligible post-secondary institution in the state of Washington. The plaintiff, Joshua Davey, had met all of these requirements. Davey wanted to double major in pastoral ministries and business administration. Davey met with the financial director for the Washington School Northwest College, which was the school that he was planning to attend. He was then informed that he could not major in pastoral ministries, and if he did, he would be in violation of his scholarship. After he refused to sign a document saying that he would not pursue a degree in theology, they revoked the Promise Scholarship and wouldn't give it to him, and he thought that this violated his First Amendment rights.
So the significant legal issue of this case was rooted in the matter of whether the state of Washington violated Joshua Davey's fundamental rights by denying him a scholarship purely because he was using it for a religious degree. His claim was that the state's refusal to fund his education at a religious institution was a discrimination against his religious beliefs and conflicted with his First Amendment right to freely exercise his religion. He asserted that the First Amendment should result in public funding for religious studies in the same way that it does for secular education. Davey argued that the Free Exercise Clause, Establishment Clause, and Free Speech Clause protects the citizens' rights to practice their religion as they wish. But what exactly are these clauses? The Free Exercise Clause protects citizens' rights to practice their religion as they choose, as long as it does not go against public morals or compelling government interest. And then the Establishment Clause prohibits the federal government from establishing a religion or favoring one religion over another. And then the Free Speech Clause gives one the right to express oneself without government restrictions. So overall, Davey argued that the Promise Scholarship Program is an unconstitutional restriction on speech. The state, on the other hand, claimed these rights under these clauses, but they focused on the side that prevented the government from establishing a state religion or favoring certain religions over other ones. The state held that forcing the scholarship for religion would cause the line in between the church and state to blur. So when brought to the Supreme Court, the court reviewed how these clauses could coincide. To make a decision, the judgment of the court took into account previous cases who had their own set of conclusions. And while there is a long list of such cases, 3 of the primary cases in common law helped to clarify their conclusion. And these 3 were Everson v. Board of Education, Sherbert v. Berner, and Rosenberger v. Rector and Visitors of the University of Virginia. So in the Everson v. Board of Education case, this emphasized that government actions cannot support religious activities. Therefore, it was justified that Washington could exclude funding for religious education. In the Sherbert v. Berner case, they focused on refining what the Free Exercise Clause looked like and allowed states more flexibility in avoiding Establishment Clause issues. And then the Rosenberger v. Rector and Visitors of the University of Virginia case held that denying student funds to religious publications was unconstitutional if funds were otherwise available for non-religious publications. The court distinguished that funding for a devotional theology degree was directly advancing religion, and Washington was not obligated to support that. And so the court ruled, contrary to Davey's claim, that the Promise Scholarship Program is not actually a form of speech. Since the program does not disprove a particular religion or religion in general, there was no validity to supporting the revision of the Promise Scholarship Program.
So the court ultimately decided that he could not use the scholarship for theology, and so for our opinions, we agree with that decision. We don't think that he should have been able to use the scholarship for this. We think that the state should have some say what their money is used for. The state is not required to fund religious activities, such as the funding of someone going and learning pastoral ministries. This could blend the balance of church and state and set it off balance. The state and the scholarship also didn't discriminate against him or anyone else that had previously gotten the scholarship, because the scholarship didn't single out any specific religion. They also didn't put any type of any penalties on religion. Also, the state and the scholarship didn't violate his religious rights of the Free Exercise Clause, the Establishment Clause, the Free Speech Clause, or his First Amendment rights. And so, for these reasons, we think that the courts and the state were correct in what they discovered on this case, and so we agree with them.
Thank you.